Hi. So what is it that your creditors don't want you to know when you file for bankruptcy? And it is not only what creditors don't want you to know, it is also something that your bankruptcy attorney is not allowed to tell you. So I can tell you this on this video, but if I'm sitting down with our bankruptcy clients, I'm also not allowed to talk about it. And you might think it's a free country and everybody is able to talk about what they want to talk about, but that's not true in bankruptcy law. In 2005, the bankruptcy law changed, and since then, bankruptcy attorneys are not allowed to advise a client to incur debt shortly before filing bankruptcy. And you would think, well, that is not that exciting. I don't want to incur debt. I want to get rid of my debt. But your creditors are very smart and they lobbied hard and long to get these provisions into the bankruptcy law. And here's why. When you want to file bankruptcy, let's say you want to file Chapter 7 bankruptcy, you have to do the means test. That determines if you're eligible to file bankruptcy, to file Chapter 7. And if your income is above median, that means your income is above the median income in your county, you would have to look at your expenses if you still can file Chapter 7. And if you have a lot of secured expenses, for example, you make payments on your car, these expenses can be fully deducted from your income. And that might lead to the fact that you can file Chapter 7 bankruptcy. If you don't have these secured payments, you might not be eligible and you would have to file a Chapter 13 and repay some of your debt. So if you're in the position and thought about getting a new car and a new car loan, a Chapter 7 would be beneficial for you and incurring the debt would be beneficial for you. But your bankruptcy attorney is not allowed to tell you this. What you can do in that situation, you can ask your bankruptcy attorney, so what would happen if I get a new car loan? Well, then the bankruptcy attorney can explain to you that that would make you eligible to file Chapter 7. But even though the bankruptcy attorney would see, oh, if that client gets a new car loan, the client would be able to file Chapter 7, would save a lot of money, and would not need to go in a Chapter 13. But the bankruptcy attorney is not allowed to tell you this. So the bankruptcy attorney is not allowed to give you real good legal advice. That's just how the law is. And you would say, well, that's unconstitutional. Well, the Supreme Court decided the question and decided that's totally fine. It is constitutional, and bankruptcy attorneys cannot advise clients to incur debt, even if it would be beneficial for the client. And the same is applicable in a Chapter 13 bankruptcy case. In a Chapter 13 bankruptcy case, you might have to pay a portion to your unsecured creditors. If you have a secured payment, the secured payment is deducted from your money you have left over every month. So if you have a secured payment, you pay less to unsecured creditors. So to have a car loan might be beneficial if you have a new car or a relatively good car, you can drive safely to and from work. It will benefit you, and you would have to pay less to unsecured creditors. This is something your bankruptcy attorney cannot advise you to do. So here again, you would have to do the first step and talk to your bankruptcy attorney about the fact what would happen if I get a new car loan. And then the bankruptcy attorney is able to tell you, well, it would lower the guarantee to unsecured creditors and you would have to pay less in your plan. So if you have any questions about filing bankruptcy, contact us. We're happy to tell you everything what we can tell you. But keep in mind, there are some things the new law prevents us from telling you. But with that video, you know about it. Thanks a lot.